Hello everyone and welcome to today's Mondak webinar in association with Agama Law Associates and an expert panel who will be providing an insightful discussion in which they will unpack the evolving world of Indian insolvency and bankruptcy. My name is Dan Sampaio and I'm joined by a brilliant panel to take us through today's discussion. But before I hand over to Achana to begin today's webinar and introduce you to our panel, a quick housekeeping item. You can submit questions to our panel by typing them into the questions pane of the toolbar on the right-hand side of your page, and we will endeavour to answer as many of those questions as possible. It's now my pleasure to hand you over to Achana to begin. Thank you.
Thank you so much, Dan. Agama Law Associates extends a warm welcome to all our distinguished panelists and all the listeners there. Mr. Sanjay Jain, Mr. Goyal, Mr. Rai, and Nitin, my partner in crime. Mr. Anil Goyal is the founder and chairman of AAA Insolvency Professionals. It's one of the first two insolvency professional entity to be recognized by the IBBI. He is going to bring the voice of the professionals in terms of this practice. He is also one of the most experienced insolvency professionals in the country, as he has concluded 17 CIRP assignments, 11 assignments of liquidation, and 4 assignments as a process consultant in his own name. Other than 300 plus CIRP and liquidation processes where the AAA insolvency professionals were providing their support. So welcome, Mr. Goyal. We also have Mr. Jain, who's CEO at Aditya Birla ARC since August 2018. Mr. Jain has 30 years of experience with the financial markets, particularly with stressed assets and project and corporate finance. Before he joined Aditya Birla ARC, he worked as president and COO at the ARCIL, which was one of the primary asset reconstruction companies of India. Mr. Sanjay Jain has managed diverse portfolios, including capital markets, fixed income group leasing SPUs, and has been on deputation with SBI and project appraisal. Counsel Mr. Sumit Rai is our next panelist. He is an independent counsel with over 16 years of experience. Mr. Rai practices across forums, including before the National Company Law Tribunal. He has advised various regulatory bodies, continues to do so, public sector units, and varied international and domestic corporations, especially in relation to dispute matters. He's quite sector agnostic and he has extensive exposure to infrastructure, construction, and other works. Mr. Jain, who is my partner at Agama Law Associates, has over 17 years of experience in the legal industry and has contributed to various strategies for legal and regulatory issues and worked very closely with large businesses. Nitin has held various advisory roles, especially in the field of insolvency and bankruptcy laws. He has been part of a successful completion of CIRP processes and has represented all interests, creditors, debtors, and also home buyers. So welcome all of you. We are here today to untangle the medley of rights in the Indian insolvency and bankruptcy landscape, and have brought together for you various perspectives from practitioners dealing with different aspects of the insolvency and bankruptcy code. The current code lays substantial emphasis on resolution mechanisms and is largely driven by creditors, whether financial or operational. This is supposed to facilitate greater transparency and accountability and improve businesses overall, the business health overall. But is it doing that? In all of this, how does the rehabilitation of struggling businesses fit in? We are about to find out. According to data from IBBI, out of 6,815 cases admitted under the IBC, about 55% of the closed cases have been rescued. The average recovery for creditors has ranged between 32 to 43 cents per US dollar for an ongoing concern and 168 cents per US dollar for liquidation on the basis of liquidation value of stressed assets. So is this good enough? Can we expect more? Owing to its robustness, IBC has also allowed complex high-value business to be rescued, resulting in substantial recovery for creditors. Is this true? We will find out. With the intention of understanding the contours of this robust law, we will begin our panel discussion today. But before we begin with specific questions, we would like to understand broadly from Mr. Jain and then from Mr. Goel how they view the movement of the code, the growth of the practice, and whether the code has lived up to its name in the last 8 years. Over to you, Mr. Jain.
Thank you, Archana, and good afternoon to all of you. So, what we witnessed that Indian banking sector was having or was grappling with high level of stress from 2012 onwards. At that point of time, it was felt very strongly that available mechanism for resolution of corporate stress, namely SARFAESI provisions, DRT provisions, BIFR provisions, or various mechanisms provided by RBI like CDR, were not very effective. So there was a need that we have some comprehensive law which can tackle the high level of corporate stress in Indian banking system. In this background, in 2016, after a lot of consultation, this IBC, Insolvency and Bankruptcy Code of India, was enacted by Parliament of India. Let's see whether it has really achieved its objective. I think there were two major objectives. One was resolution of corporate stress, and second was redefining the relationship between lenders and borrowers. Coming to resolution of corporate assets, I think it has been a transformational law. In last 7-8 years till June 2024, Archana has already given the numbers. The total recovery has been 32%. And if we compare this recovery vis-a-vis other ways of mechanism, be it SARFAESI or DRT or BIFR, this number is significantly higher. And if we look at the recovery vis-a-vis the liquidation value, it is over 160%. If we see this number for any other mechanism, again this number is much higher. Apart from that, we have seen more than 1,000 cases which have been resolved before they were admitted with IBC. And more than that, some 1100 cases have been withdrawn under 12A. So from that perspective, the IBC law has been very transformational in resolution of corporate stress assets. Coming to the redefining the relationship between borrower and lender, I think it has played much bigger role. The relationship between lender and borrower has been completely redefined. Now, borrower is really under pressure that if he were to default, he may lose his company. And that has made both lender as well as borrower to be very careful while they are borrowing or lending money. And that is also reflected in slippage ratio, which has come down drastically. If we look at the slippage ratio during 2014 to 2018 was ranging around 4 to 5% per annum. This slippage ratio in 2024 in corporate assets has come below 1%. I think that is really transformational. So when we talk to the bankers, their only point is the corporate incremental stress is very low, and that IBC has played very important role in redefining the relationship between borrower and lender. And certainly it has helped the banking sector. The GNPA numbers have come down. The GNPA, which was 11.5% in 2018, has come down to 2.8%. And all these numbers are really reflecting in the return of assets of banking industry. It was negative in 2018, and now it is 1.3% for banking sector. So from that perspective, I think this IBC has played its role. Having said that, there are concerns that IBC process is slow. And if we see the average resolution time taken for resolution of In IBC cases, it is 500 days. In many cases, it has taken 3 years, 4 years, 5 years, sometimes 6 years. So I think there is one concern that the process is quite delayed. I think all the stakeholders need to work to make the process faster so that this IBC process is much more effective. With this, I will conclude my comments.
Thank you, Mr. Jain. That was very insightful. Mr. Goyal, you have been a pioneer and you have seen this since inception. You are responsible for carrying the mandate of the code out. So how do you see the evolution, and what is your take on this?
Thank you, Archana, and thank you, Agama Law and Mondec, for giving this opportunity to us. So I think Mr. Sanjay Jain has already said various numbers, which are in fact significant, and those numbers are known to everyone in the industry. I would just be sharing the first-hand experiences like we had when we had the first few cases, and over the last 7 years now we have the experience of taking control and custody of more than 350 cases of CIRP or the liquidation. So the fear of like the company going away from the hands of promoters, that has actually played a pivotal role in the Indian economy. And as Mr. Jain has said, that the slippage to NPA has declined. So the best use of the insolvency law in India is when we are not using it. Just the law being there has impacted a lot. So the slippage has come down. The fear of losing the control over the company has actually, I have actually known the cases where the promoters have sold their precious properties and the jewelry because they don't want to lose the business. Business is something that they are surviving on, so they don't want to lose that business. Therefore, they are not slipping to NPA because now they are seeing that in case we become NPA, that the banks have better options. Even under SARFAESI, in some cases, like see, like we have handled like kind of thermal power plants, hydel power plants, tea gardens, like technology companies, multiple locations, retail companies. It was not really possible to take action under the SARFAESI law and in those segments. But now, nobody could ever think that a company having too many tea gardens, one hall where the COC members are sitting, that company can be taken away by somebody else. And that person, the promoters are completely out. So this fear of losing the control on the company has worked better in this Indian economy rather than the actual resolutions or actual liquidations. I would also like to add one more thing. When the data is being released, that this much of percentage is the recovery in CIRP or this much is the percentage of recovery in liquidation. I'm only saying that when we receive claims, the claims are also having kind of interest for 6, 7, 8 years, and in some cases for 20 years. And we try to see how much is the haircut, and that is presently being calculated from the amount of the claim and the amount of recovery. Honestly, it should be seen vis-a-vis the liquidation value of the company. What are the assets? What is the value of the business based on the discounted cash flows? And what is being recovered under the insolvency law? So in case we are recovering better, then we should say that we are recovering 150% of the liquidation value rather than saying that we are recovering only 11, 12, 13% of the total claims. I have examples with me where actually the loan was 2 crores and after 20 years I have received a claim of 2,500 crores because of compounded interest, like liquidated damages, penal interest. So now, when originally the asset was created, those assets were created with the capital expenditures of 2 crores or maybe 3 crores or maybe 4 crores. Now, those assets might have been appreciated, but not to the extent of 2,500 crores. So still somebody will say that the recovery is only 5% of 2,500, but nobody will say that the original amount was 4 crore and we have recovered 40 crores now. So with this, Archana, I would just say that our experience has been very good, and the best use of the insolvency law in India, the impactful, uh, the impactful uh, insolvency law is only in case it is not used. Just having it here in this economy, it has played a very, very pivotal role.
Right. It's like having a blood test every 6 months to ensure that your sugar is in control or something. So thank you,
Yes.
Mr. Goyal. That was very insightful. With that, I'm going to jump to Nitin. Nitin, you see this process from both sides, both from the creditor and debtor side. So, do you think that the interests are balanced, or as a legal practitioner, what is your take on, the challenges in achieving this balance?
So thank you, Archana, for the wonderful question. So when look at the interests are sometime when you are in court, they are not aligned. Each one want to have the piece of their cake, basically. So I make it into more like a hexagon theory. In the hexagon damages, if in the angles of hexagon, if I say first, most people who are very eagerly approaching the court are operational creditors to get the 100% money out of it before it goes into CIRP, because they are very well aware that if it actually moves into CIRP, they are the most insignificant ratio of the entitlement what they would achieve. The second most comes are the financial creditors. The entire stakes of financial creditors are very well into the more of giving liquidity to grow the business and economics. But the moment there are defaults, they are the first one to recover and de-risk themselves as a financial institution and as the lenders, basically, so to say. So their interests are definitely to see the maximum realization by reviving the company, and if they are not able to, then definitely the liquidation becomes the last resort. Then comes the interest which courts need to see most of the time is the IRPs and RPs role. As Mr. Goyal said, that sometime being a law there itself is someone to keep a watch and continue to walk the path straight. Having said that, sometime IRPs and RPs, who are the main watch or ward or code of conduct to follow properly to ensure that the insolvency process has been adequately followed to revive the company and liquidating. If they are handicapped and they are having certain challenges, then courts always give them a support, back them by filing various intermittent applications from time to time. So that is the role of the third party IRPs and RPs. Then moving to the COC, COC plays an extremely important role, sitting as the main controlling voting rights, having the taking the decision of the best of the value, best of the interest in the company. So the representation from the COC, from financial creditor to now after the recent amendment from, of course, OC as well, plays extremely important role. And last but not the least is the liquidator's role, which also is significantly plays an important role of the liquidator, because even as Mr. Jain and Mr. Goel has pointed it out, the values which are recovery looks in numbers extremely low, or I would say a very, very extremely low, that you got 3%, 5% recoveries, but the liquidation values sometimes have been far more achievable because of the complete ecosystem which IBC has provided so far. So that's why I put this into a six hexagon points for each of having its own interest. And I think NCLT becomes more like a grandfathering, helping all each side to strike the balance.
Yes, that's quite comprehensive, Nitin. I'm going to pick a thread from what you said. about the operational creditors and jump to Sumit. Sumit, as a counsel who's always advocating, who's able to advocate both sides of the coin, what is your opinion on how operational creditors should navigate their claims? What would be their general approach for outstanding issues, especially where it's a David and Goliath situation, like there's an SME and a PSU has, sort of it's the PSU on the other side. So how does this work? Is insolvency bankruptcy code a good place for the operational creditors to get relief? Something on that from you.
Thanks, Archana. Good afternoon, everyone. Jumping to the question directly, my answer would be I know that this is the question that is often asked by small businesses or contractors, vendors, etc., who look at IBC, who are told or who have heard about it. They may not have detailed knowledge of it, but have heard about it and have started feeling that it is one more remedy they now have in recovering their money. You may call IBC anything. You may call it unique, path-breaking, give it whatever adjectives you want. But one thing that it is not is that it is not a recovery process, particularly for operational creditors. So any business or any contractual dues that you have against a company, first, we should keep it very clear in our minds that IBC is not a methodology that has been evolved for you to go to court, NCLT, file a Section 9 petition, and you will get that money back. In fact, the truth is that if your petition under Section 9 of the IBC code gets allowed, you get nothing. In fact, operational creditors often at the end of the process, except if it's a company which is doing very well, in which case it will not be in that position, will not get anything. Most of the resolution plans will end up giving a few single percentage points to operational creditors. So it is not a recovery methodology, but why is it today considered so? It's the same or kind of similar situation as we would consider in litigation strategy the erstwhile winding up petitions. You would note that if a winding up petition gets admitted in court, as the person who had a contractual due and admitted liability as an operational creditor, that's not what you really wanted. What you wanted was that your filing of the petition should threaten the company sufficiently enough to come to the table and come to a settlement and pay up. That's precisely what the utility of IBC remains for operational creditors even today. It's like a gun to the head. You have to shoot the gun, you get nothing. If the other person gets sufficiently threatened by that gun and cuffs up the money, you go home happy. So I would say that as far as IBC is concerned, there is little there for operational creditors. Yes, it is definitely an option that you can go bring the facts to the attention of the NCLT. You will end up, if you succeed, doing some public service, but you won't get monies. Your recovery modalities will still be the traditional methods of going to court, filing a suit, arbitration, for MSMEs, the Facilitation Council. And one thing, as Mr. Goel had pointed out, that the existence of the law is good enough. See, today IBC causes sufficient threat to any business which wants to continue the business. So in such situations, if your assessment is that definitely you overcome the high threshold of a undisputed claim and you know for a fact that the business wants to continue, the management wants to continue the business, then you can take a chance, go to IBC, and probably that will wake up or shake up the organization. Other than that, I don't think IBC is the best place for operational creditors to go to recover their dues.
So I think that's if Mr. Goel wants to add something there.
Yes, Archana. Sumit, I would like to add some thoughts about the operational creditors. What you have said, I 100% agree with you. I would also like to say when this why these operational creditors are not getting, why are they the last at the Section 53 distribution waterfall arrangement? One, they are the first one to know the financial position of the company. The
Correct.
workmen, the employees, the suppliers of services, suppliers of goods, they would be the first one to know the financial position of the company. And they have the first responsibility to start insolvency in case they are not getting their payment, even if it is delayed by 1 day. Even if it is delayed by 1 day, if I have a purchase order where the payment is due on 60th day, I will not have to wait for account becoming and slipping down to NPA. On 61st day, I will have the right to file an insolvency application by just giving 2000 rupees as the fee. So this is the best thing for the operational creditors that have happened in India. So far, all these operational creditors, they were having only one recovery method in India, just to develop the social relationship with the customers. And they would go on Diwali, they would go on Dashera to them only to develop good relationships, so that they also come to know about the credibility of the company, they come to know about the promoters, and then finally they will also do taqaza. Now they have a right that on 61st day they can file an application in case their payment is delayed. Now, their risk is the least. It is only limited to one supply cycle. Only one supply cycle. If a person is issuing an invoice of 10 lakhs of rupees each time, so his risk is only 10 lakhs of rupees. Unlike the financial institutions who have lent 1000 crore, 2000 crore, they have lent working capital worth thousands of crores, debenture holders, shareholders, so their risk is much, much higher. Therefore, they are protected. Who brings the industry? Who brings the business? In any economy, it is the lenders, not the suppliers. Suppliers are exposed only for one supply cycle. If I'm extending a credit of 3 months, only one supply cycle is at risk. If I'm not getting payment, and most of these operational creditors will get settled in case the operational creditors take action timely. Now, what happens? The operational creditors, the suppliers, they still are going the same way as they were doing earlier, like 10 years back. They are continuing their supplies even if they are not getting payment. So this is a voluntary risk. They are taking a voluntary risk, and then they later on they are repenting. They are saying that the law is not made in their favor. In fact, this law is in favor of workmen, employees, suppliers, because they are the first one to get the information about the financial position of the company. They, like, 90% of the applications under section 9 are getting settled. How are they getting settled? By full payment or part payment or by way of an MOU. 90% of the applications are getting settled. So that means they are getting a recovery. So this is lawful for them. So the only difficulty was it was too much of pressure on this court. So therefore they increased the limit to 1 crore.
Correct.
Therefore, I would like to add that this law is the landmark law protecting the suppliers, protecting the workmen, protecting the employees. This is what I just wanted to add that.
That's a very unique perspective, Mr. Goyal, and I think it kind of explains why the law is made this way. But I'd like to jump to Mr. Jain, taking a thread from what Mr. Goyal said. All of these decisions are made by the uh, committee of creditors. So, can you throw some light on how this committee functions? What are the key things that they keep in mind when they're approving plans? And in fact, one of the viewers has asked, why is there such a huge haircut that they accept? So, do you want to throw some light on this?
Well, so the COC roles, duties, powers have been well defined under IBC and under IBBI rules. And once a company gets admitted in IBC, then COC de facto become promoter of the company, because all the powers of board of directors get vested with the committee of creditors. And RP is running the company like a chief executive officer of the company under the supervision of COC. And of course, COC has to work within the framework of IBC and IBBI rules and regulations, and their decisions can be challenged before the appropriate forum. So it is very well defined, and COC has to work, and COC has to ensure that RP is working for RP is smoothly running the company, and the business plans are being achieved, and ultimately objective is to resolve the company and to hand over the company to the new applicant who can run the company at more appropriately. Question how these resolution plans are evaluated. So when we are inviting a resolution plan from prospective resolution applicants, we come out with something called RFRP, and we also give with evaluation matrix to the prospective resolution applicants. And based on those two parameters, all these plans are evaluated. The focus is the unit should be revived, and the value to all the stakeholders should be maximized. And this process is run very transparently, and everyone is aware how they can score high marks. And based on all these parameters, COC takes a decision that who should be the successful resolution applicant.
Understood. So that's a wonderful overview. Just on now, completely shifting gears on the topic because I can see that we're already halfway through the webinar. Just I'm going to throw a question to Nitin and Sumit. How do you advise clients on the decision of insolvency versus arbitration? This is often a question that is raised, and I'm not just speaking from the perspective of an operational creditor, but how do you see these two processes pan out, especially since arbitral awards can also be enforced through the insolvency process? Maybe you could take the first go, Nitin, and then Sumit can jump in.
Sure. Thank you, Archana. So, with regards to the arbitration versus insolvency, I think whenever client approaches, the answer really remains very clear to us as an advocate uh, to the client is commercial wisdom, commercial decision to whether they have any existing or a pre-existing dispute. After the Mobilox case, I think every thread of the interpretation of pre-existing dispute has been clarified to the great extent. And if the client himself comes and submit the documents, and based on the assessment we feel that there is a even iota of doubt of pre-existing disputes, we would always recommend to go through a appropriate recovery mechanism, which provided they have an arbitration clause, then of course this need to be led through a complete process of arbitration. Having said that, if the client is very clear, black and white, the invoices are submitted, the goods are delivered, the payments have been acknowledged by the corporate debtor, there is a balance confirmation to that extent, then it's a no-brainer, and the threshold is the courts are very seriously. They are not allowing them to make a clubbing of the different amounts to reach the threshold. So it depends upon the clarity and the acknowledgement and the undisputed amount. Accordingly, we advise the insolvency. Otherwise, the best way is, provided they have an arbitration written agreement, then go by arbitration. Over to you, Sumit.
I think Jin has covered it essentially, but I will just add that there are two, three considerations. First, of course, is that you should meet the high threshold that is now being set. In the initial days, NCLT was a little more liberal in allowing claims to go in because the meaning of undisputed claim was not clearly understood at the time. But now we have come back to the same high threshold or similar high threshold that used to be for admission of winding up petitions in the High Court. Uh, so basically, and also the fact is that depending on the bench, today a case that you file under 9 to get a decision on it may sometimes unfortunately take even up to a year. So you would not want to waste your time if you know for sure that it will not stand scrutiny. But still, I think there are considerations like if there is no arbitration clause, then you are relegated to going for a suit. So you may decide that let's take a chance. And even though you know that your chances are slightly uh, not very clear, it's essentially a fact-to-fact determination on the strategy. Uh, because IBC can be used to create that threat, because that threat of for any management who wants to continue the business, that threat matters.
Okay, thank you, Sumit. I think the discussion so far has been kind of assuming that everything is happening in India. I have a question for Mr. Goel. How do you see cross-border insolvencies panning out, and do you think that we have the necessary infrastructure to deal with it? Is the government able to have the necessary relationships with the foreign governments to make this process very smooth? Especially, we all know what happened with the Jet Airways case and how things were in murky waters in that sense. So, your take on that, Mr. Goel?
So, Archana, so far in India, this cross-border insolvency has not been implemented, although we have two sections like 234 and 235 of the IBC, which says that the government can actually have bilateral arrangements with other jurisdictions or other countries. But the real implementation of the cross-border insolvency would be when the complete model law would be implemented in India. In fact, UNCITRAL model law, which is United Nations Commission on International Trade Law, they have a model law on cross-border insolvency. And in fact, most of the countries have already implemented it, like
Adopted
US,
that.
UK, Singapore, and Japan. They have already implemented that UNCITRAL or UNCITRAL model law. So that is required to be implemented. Presently, we are facing difficulties because whenever we have some kind of assets in other jurisdiction, so there is a conflict and we do not have the acceptability of our power. Because see what we draw, like as an RP or as a liquidator, we draw power from that NCLT order. That is the order which is valid in India jurisdiction. That order does not give us powers when we change our jurisdiction to other country, so we
That's
are not able to take control and custody of the assets of which are lying in other jurisdictions, other countries, and we are also not able to recover any money from the companies across the globe. In case any company that we have and that company has some dues from an overseas company, then we will have to go to that country, and under that particular law we have to file another insolvency application under that country's law. So therefore presently we do not have that model law. We do not have any other law may be amended. We do not have any one or two, maybe other than one or two, we do not have any bilateral agreements. Now our judgments are not enforceable. We cannot rely on the overseas judgments. Also, there is no coordination and there is no acceptability of the orders. Asset recovery is difficulty, so there is no reciprocity of the agreements. Now, under this scenario, what I can say, the India has this need now because most of the Indian companies or many of the Indian companies are actually now going abroad across the globe setting up businesses. Most of the global companies are coming to India and setting up their businesses. So there are imports, there are exports, there are investments across, there are external commercial borrowings across here and there. So therefore, the need for cross-border insolvency is definitely there, and we are expecting something in the coming winter session as amendment to insolvency law, which might have some major amendment with regard to the cross-border insolvency. But as of now, it is difficult to have that kind of enforcement as we have in India. We do not have any rights over other jurisdictions. Yes, Archana.
Thank you, Mr. Goyal. That is. I mean, I kind of agree with you that that's a big lacuna today, especially given how our businesses have become global in nature. So I would like to take this to Mr. Jain and ask him, how do you feel, sir, has the credit risk management system overall in the country improved, or do you think that lenders are now trigger happy to kind of go and enforce their rights under the IBC? How do you view this? Mr. Jain, you're on mute.
So as I was mentioning in my opening comments, the credit underwriting quality has improved a lot in last couple of years, which is also reflected in the slippage ratio in corporate sector, which has come below 1% in FY24. Of course, both lenders as well as borrowers have become cautious, and we have seen that even borrowers are not going for over leverage. Generally, they have certain yardstick. Of course, our equity markets are also helping because they can easily raise money from equity market. But otherwise, also borrowers have become very, very cautious. I keep talking to many promoters and promoters who really face challenging time in past couple of years, but came out with difficult times. Even they are not borrowing money. Generally, corporates have yardstick. They don't want to leverage more than 3 times debt to EBITDA time, which is very, very comfortable for any corporate. So from that perspective, I think the environment has become very, very positive as far as lending quality is concerned. When we speak to the banks, they are not seeing incremental corporate stress in their books of accounts. When we go to banks, the number of staff handling these NPL accounts have come down. The amount of NPLs have come down drastically, and certainly it is good. And they are focusing more on retail side because and on corporate side the credit offtake is relatively low, and they are asking much fine terms, which lenders believe they are not attractive, and they are more focusing for SME or retail lending.
Okay. I think yes, maybe we need to understand the role of the lender as well as the role of the RP in the whole process, and it has to be, there has to be a balance between how they see the business and how they see their recoveries. I guess that's what you are driving at. Uh, Sumit, I have a question for you, unconnected with what we were discussing just now. I'm going to jump straight to understanding in your experience, because you have the benefit of practicing before various legal forum. What is your view between arbitrations or forums like Securities Appellate Tribunal? What is the interplay or issues that you have with IBC? If you can throw some light on that.
Yeah, the interplay is that IBC has come as a tsunami. It has overtaken everything. Uh, so I'll give you an example. You may be having an arbitration claim against a company which is ongoing for 2 years. Big claim, big project, uh, claims of about 150 crores. One fine day you get news that the company, a CIRP process has started and CLT has admitted a petition. The arbitration ends then and there, immediately, without much ado. There are complicated interplay issues that arise. For instance, in a matter that I was doing, there was an issue where the question was what happens to the counterclaim, because the moratorium only applies against the company, it does not apply for the company, and the company was running a counterclaim. So then it's up to the RP to then take forward that claim if he wants to. Usually the RP will not have the wherewithal in that very limited time in which he has to. A liquidator stands in a different footing, but a RP has a very limited time to do a lot of things. So to pick up a big arbitration and give appropriate instructions, appoint lawyers becomes difficult. Uh, in securities law also, it causes some very interesting problems. One question that arises is what happens to the ongoing compliances of listed
Right.
companies. That's a big issue. I think there is some guidance by the IBBI also on that, where they say that the RP will be responsible for all ongoing compliances. One issue that I dealt with in SAT was of what happens to the trading of the shares after the CIRP has begun, but the resolution plan is not yet accepted. So, a position that was evolved by the stock exchanges and SEBI in consultation was that you stop the trading as soon as you come to know that the COC has allowed or accepted an RP. Because in most of these resolution plan, what happens is you wipe off the shareholding. So the public shareholders will no longer have any shareholding. So in that cases, if you are allowing the trades shares to be traded, then somebody who is not aware of it may buy it, not knowing that the share is of no value. But SAT took a slightly different view, saying that you have no business stopping because it is contrary to the interest of the investor who is holding that share. So only the day on which the clean slate principle applies, which is the day on which the resolution plan comes into effect, only on that day you should stop. Now, this is not the ideal situation from the regulator's perspective. I think the SEBI has come out with some uh, working papers, etc. They are considering what best can be done to protect public shareholders in these situations. It's a very complicated interplay, and I don't think SEBI alone can do anything in it. It is something where the ministry, which looks at both regulators and the entire law, will have to think whether some exceptions, certain different situation needs to come out for listed entities. So these are some of the
Fair enough.
interesting interplays I have seen.
Fair enough. I think that's a very interesting perspective. But one thing occurs to me on hearing all of this is that we have left the poor promoters out. Mr. Goyal, what is the fate of promoters and how do you keep them at bay? I mean, on a lighter note, but on a serious note, how does it work out for promoters? Do you see them really using this as a tool for rehabilitation? Sir, you're on mute.
So, in fact, this pre-packaged insolvency resolution process is all about seeking a restructuring or a resolution which is pre-planned and which is pre-agreed by the creditors. Of course, that has not taken off so far in India very kind of efficiently, but in the international space, this is a successful model. In fact, in America, what we call it as Chapter 11 is exactly what is pre-packaged insolvency resolution process, because in Chapter 11 we say debtor in possession. In pre-packaged insolvency resolution process also debtor remains in possession. Debtor continues to keep the company as a going concern. Debtor is responsible for all the risk and reward, and nothing actually. The only RP is only monitoring the operations. RP is not responsible for keeping the company as a going concern. But since the pre-packaged insolvency resolution process is not working, so especially MSME, where the promoters are also permitted to submit a resolution plan, despite Section 29A is not, they are not eligible under Section 29A because of Section 240 capital A. They actually have the relief that if they are MSME, then the promoters can submit application and resolution plan, and their resolution plan can also be approved. So this is one way that the promoters can also seek restructuring, especially for MSME, which is also called mom pop companies, where the management is
Right.
primarily with the promoters. So they are the appropriate entrepreneurs who actually can revive that company most
Got
effectively.
it.
The only scenario is that they actually have landed into a difficult uh, and debt and equity ratio, so they are not able to service their debt. So in case that debt is brought to the level of serviceable level, then they can survive that business much better than any other person. So therefore the MSME, the definitely promoters can seek the uh, best resolution. But the only thing which comes is the greed. Like in case now we have gone into the insolvency, we should try to give the least possible amount as a resolution amount to the lenders. So that is where the lenders are not happy. They are saying that in case the company is going back to promoters, they should actually offer us something which is slightly and which is substantially more than the liquidity value. So this is
Right.
the main fight, where the lenders are saying that if the promoters are taking back the company, they should offer us substantially more than the liquidation value, whereas the promoters are sticking to the liquidation value, which somehow they come to know. Now, the overall objective of the insolvency law is to protect the business, and protection of the business at like various uh, kind of efforts that the government has made. Even the pre-packaged insolvency resolution process is also part of it. The promoters should use it, and in fact, what we recommend, that is PIRP or PPIRP, that should be available to even all segments, even all uh, non-MSME also, because this is the effective, this is cost effective, this is faster, and this is mutual. So this is where the promoters have to come with the best offer that they can give. The lenders need to trust them again. The lenders also need to give them some time to revive the company and pay. Presently, most of the lenders in India, they are saying that we want upfront recovery. We want recovery within maximum 1 year, preferably in 60 days. So therefore, the promoters are unable to do that. So in case there is a little change in the mind of the lenders, in case they are able to provide some time to the promoters with restructuring, I believe uh, the promoters can still revive that kind of companies. When we deal with the promoters as RP, as liquidator, we try to understand them, we try to work in a complete neutral manner, impartial manner. We do very, very fair investigation into their transactions, maybe under section 43, 45, 49, 50, 66. So we do very fair investigation. We, in fact, address all the key managerial personals. We address all the suspended management. We spread positivity. We always convey the message that this is a restructuring process and the company will continue as a going concern. The jobs will continue. The suppliers will continue. The customers will continue. So therefore, that's the way we handle promoters. We
Sure, sure. Thanks.
don't see,
Thanks.
yeah, yes, yes. We don't see any kind of bias against the promoters.
Right, right.
So,
Understood. Mr. Jain, you would have a diametric, different view, I'm
no, I,
guessing, on this
no, I
point.
have no
So,
different view. I just want to add to what Anil has told, that the promoters under Section 12A can also submit settlement proposal once company is admitted. And we have seen almost 1,100 cases have been settled under 12A. So it's even 12A. So promoter still has a scope if they can gather resources and they can come out with a plan which meets the expectation of COC. Certainly, they can take back the company under 12A.
yes, a fair point. And one of the questions from the audience has been that do you see sector-specific insolvency framework as a viable option? What is your view on that, Mr. Jain, especially in the real estate sector?
So I think on real estate side, IBBA has taken a lot of measures. So you can do project-wise resolution. And the flat buyers, they have been given status of financial creditors. So I think a lot of measures are being taken. I really don't understand. No, what do you mean by sector-wise specific resolution? We have seen a lot of experience has been gained by the resolution professional and COC in last 7-8 years, and we know how these various sector dynamics do work. Most of the companies which have been revived are asset-heavy companies, and I think COC and RP do take help of sector experts in resolution of cases, in marketing the cases to prospective RAs. So sector experts help being taken. So I think there is no need for sector specific experts as far as RP is concerned. But when RPs are appointed, certainly they are supported by the process team, and process team is having a lot of experts who is supporting RP. I think Anil can further add to this particular point.
No, see, like this industry expert is something that we are allowed to appoint with the permission of the Committee of Creditors, and the Committee of Creditors is the best, kind of, it's a structure that has been made. It is a completely recognized framework. So they are supposed to have the best knowledge about the corporate data, and they would also recommend at times that in case we want to handle the operations, then we should have some industry expert who actually talks in the favor of the creditors and RP. So the whatever promoters are saying, there should be someone to verify that kind of ratios, like the consumption ratios, market price of the raw material, market price of the sales. So everything actually can be verified from an industry expert.
Understood, sir. Nitin, there's a question from the audience on the waterfall mechanism and employees. How do they recover their dues? If you can just quickly, sort of throw some light on that.
So, employees are not kept separately at bay. Their claims are to be recognized as any other operational creditors by the resolution professional. And once they are being taken and accepted as a claims of their salaries, there are certain benefits for the statutory dues like gratuity and PF. And once their claims have been accepted by the resolution professionals, then in the basis of the provisions of IBC, where the waterfall mechanism is very clearly laid down, I guess, under Section 56 and so on and so forth, where they will get a not any prior in time right, but they will certainly get a rights as a particular class of people for their claims to be settled in the time of resolution plan being approved or at the time of liquidation. Mr. Goyal, you being on the ground accepting these claims from the employees, how do you practically differentiate the part of the statutory dues versus part of the salary?
Now, this is the Supreme Court has already held that the gratuity has to be paid 100%, and 100% to the extent that that would not even form part of the liquidation estate. Similarly, the provident fund dues are also supposed to be paid 100%. Superannuation fund is also supposed to be paid 100%. But as far as the workman dues are concerned, workmen will get pari passu along with the secured creditors, but the employees are not preferred. Employees will get only in case the workmen and the secured creditors are fully paid off. So in case the salaries are outstanding, other than provident fund, gratuity, and superannuation fund, the repayment of the salary would be very difficult to recover. So
Understood.
as I said earlier also, employees and the workmen are the first persons to know the financial position of the company. In case the
Right.
company is not able to pay salaries or wages for 1 month or 2 months, they should actually jump out of the sinking ship. That is
Thank you so much.
what the norm says, because they will not get anything. But in case, that is what I always advise, you should be mobile, you should have capability so that you are absorbed to other companies. But in case you have no capability, then uh, even if you are staying with the company is bad, you will not get your salary. So you should actually jump out of the sinking ship in case you are an employee or you are a workman. That is always better.
Thank you, Mr. Goel. One last question for Sumit. You have spoken of the interplay. We don't have much time left, but I think one last question we can answer. What happens to criminal proceedings, especially white collar crime or money laundering, etc.? What happens to those kind of proceedings? Can they continue against the promoter? Sumit, you're on mute.
I think in very recently, Supreme Court has clarified this, if I'm not mistaken, that a moratorium does not apply to proceedings against individuals, even if they arise out of the liability when you were working as part of the company. Even a Section 138 kind of a situation will continue. So nothing happens to those cases. Those cases will continue. It is only and only cases against the company. And because when you enter the realm of criminal law, it will always translate to an individual against whom the charge will be. I believe those will continue. The intent of moratorium is only to give time to the resolution professional to try and see if he can resurrect the company. And these criminal charges will, against erstwhile management will have nothing to do with it. Yes, Nitin. I
So,
think, Nitin, I wanted to
uh,
add something.
yeah, thank you, Sumit. I just said recently I've come across this case of a director of enforcement versus Axis Bank. You said, which very clearly said about this criminal proceedings and the PMLA proceeding will continue irrespective of the moratorium. However, a very recent position in NCLAT in the month of August, which has also clarified certain parts for the resolution applicant, basically to release those assets which are under the realm of the PMLA and attachment, basically. So that case was Vantage Point Asset Pte Limited, which NCLAT has said that it should not be applicable and affected the rights of the resolution applicant, and they have directed to release those assets from the PMLA proceedings.
Yes, I think
Yeah,
Nitin, you are
thank you.
absolutely right. I would like to add the first was the order from Bombay High Court in the name of Shiv Charan, and
Yes.
then this NCLAT order in the case of Vantage, that is following the Shiv Charan judgment and also differentiating with the Rajiv Chakravarti judgment of Delhi High Court. So since we are dealing with the 13 cases where all the assets are attached by PMLA under the Enforcement Directorate under PMLA, all cases of Nirav Modi, Mehul Choksi, Junjunwala. So we are the liquidator, so we keep a track on all the PMLA cases. So we have almost everyday discussions on this. Now, within this week, as we are talking, the government is trying to change the stand. Earlier, the government thought that this is the uh, assets of the uh, accused that we are attaching, and finally this will go to the exchequer, means central government. Now the government have started thinking that in the case of banking fraud, the in fact the victims are, we are making the victims suffer more. The victims are the lenders, and we are attaching those assets which were funded by the lenders. The banking fraud victims are bank, and the banks are further kind of reprimanded by not allowing them to sell. So the government have identified which they would like to hand over to the victims rather than continuing their attachment under PMLA.
Okay, that's a very recent change in the thought process of the government, and I think with that, one we come to a end of the wonderful session that we had in the last 1 hour, unearthing different strategies, unearthing different perspectives. Thank you so much once again, Mr. Jain, Mr. Goel, Sumit, and Nitin for being such a engaging speakers today. Thank you again, and thank you, Mondak, for organizing this. For
I think you were not audible for some time, Archana.
Thank you, everyone. Thank you, everyone, to our wonderful panel and to our audience today. It's been fantastic to have you, and we hope to see you all again soon. Have a lovely rest of your day. Goodbye.
Thank you.
Bye bye.
Thank you.
Thank you, Archana, for excellent moderating the session. Thank you, everyone.
Thank you everyone. Thanks.